Welcome to the Human Results Podcast. Good morning, Mr. Hobbs. How is Spain?
Morning, Ben. It's hot. Thank you. Yeah.
Excellent news. Excellent news. And of course, you're due back in the next week and a half back over to the UK. A different UK you're coming back to, aren't you?
Yes. Hopefully the sun will be back when we get back. But yeah, certainly the world is opening up, and even cautious Mr. Drakeford in the last few hours has released Wales from the last of the restrictions.
Excellent, excellent. Well, we're going to stay away from COVID today. I'm sure you'll be pleased to hear that. A bit of a quick fire 10-point question answer session for you that I think is vital at the minute. So without further ado, we will start. How should employers carry out right to work in the UK checks for EEA nationals from the 1st of July 2021?
Well, that's a very precise question, Ben. Certainly, from the beginning of last month, beginning of July, EU workers can no longer use their passports or national ID cards as evidence of a right to work here. I say here, as in the UK, not in Menorca at the moment. They've got to have applied for their settled or pre-settled status. That's the essence, really. Employers here are going to have to carry out a much more careful right to work check. And I know the Home Office has set out a useful guide online. I would suggest that if you have any European nationals in your midst or applying for work, and let's face it, they're very welcome, and there's 5 million plus who did apply for settled status post-Brexit. So, but you do need to make sure you carry out those checks. And obviously the penalties for flouting it are not insignificant.
That's the key, isn't it? Of course, yeah.
There's
actually
big fines, Ben. And obviously, you know, there are sectors of our economy at home who are struggling to recruit. So the temptation will be quite considerable.
Indeed, yeah. we had a conversation about Kickstart recruitment. You know, it's not it's obviously another part of recruitment. Just earlier this week, we on another publication. So yeah, it's definitely a major issue at the moment. Can employers make having had a coronavirus vaccination a condition of the employment for new recruits?
No, Ben. I mean, I have every sympathy for employers who take that stance. Everybody has as an employer has an obligation to provide a safe working environment for their employees, and undoubtedly all the evidence points to the vaccine helping to depress the spread of it, helping to make those who've got it less infectious, and obviously keeping those that pick it up less likely of becoming seriously ill. Certainly the CIPD as an organisation are very concerned that having a kind of a no jab, no job policy would give rise to claims of unlawful discrimination, for example, on disability or age. Well, I think age evaporates soon enough, because everybody over the age of 18 and indeed shortly 16 are going to be eligible to get double jabbed in double quick time. So unless an employer takes that prescriptive approach right now, and I think that would be far too premature, then I think the age discrimination angle evaporates to a degree. I suppose the issue is that younger people are statistically far less likely to be ill with COVID, and perhaps the percentage risk of being ill from the vaccine is up there, or maybe arguably has a greater prospect of being serious than the COVID itself. I'm not sure about that. So whether an employer is setting a provision or criteria or practice that all ages must get it, whilst disregarding the minute chance of a nasty reaction to the vaccine, don't know. But you know what? You've got an obligation to everybody, and the older are more vulnerable. So I think a lot of employers are going to be keen to say yes, and at the moment, I don't see any reason why not.
I'm going to go back to one of your favourite sayings. Don't be the test case.
Well, nobody wants to be the test case, Ben, but I think, the government are talking about double jab passports for events, for nightclubs and all sorts. And there's a big resistance in amongst politicians about it. But it's a debate we're going to have for some time.
What should an employer do if it becomes aware that an EEA national employee does not have settled or pre-settled status?
Yeah, I mean, it would be rather flippant just to say part company with them urgently. You know, I suppose that'd be fairly facetious. You know, the employer must say to that employee, get on and do it, get on and apply. If they're eligible, get on and apply immediately, certainly within a month. So the employer must then let the Home Office know that that is the case. As my understanding of the rules is, that will give the employer an excuse to avoid any nasty fines for the next 6 months, whilst that settled status application is being processed. And employers are expected to carry out follow-up checks. So a quick look on the government guidance on the websites around settled status would be in order for employers in that situation. But certainly it's not the end of the world, but they must basically report it to the Home Office and tell the employee they've got 28 days to bang their application in. If an employee hasn't after that period, then I think the safest option would then be to say, well, I'm sorry, we're going to have to take action to terminate your employment quickly. And again, Home Office advice would be very wise.
Use your story, isn't it? Take responsibility once you find out and deal with it. Don't leave it hanging.
Absolutely, Ben.
Can EEA national employees lose their right to settled status due to absence from the UK? Depends on the length of the absence, I guess, doesn't it?
I think yes. I think that's really the answer. I mean, if you know how long's the absence? If somebody came over from Poland 5 years ago and did 6 months and went home, I think that's probably not good enough. I think again, my understanding of EU settlement scheme is that the absence shouldn't be any more than 6 months in a total of any 12-month period. So you've got to be able to show that in essence you have settled status. You are resident and working and residing in the UK. That should protect those people that have had to rush off home to see an elderly relative, maybe nurse a cancer-suffering parent or something like that, and back home. But yeah, no more than 6 months, is my understanding, in a 12-month period. I think there are some exceptions to the rules, but I think I would, again, look it up on a government site.
I think you're right. I think the key is there. You've got to be settled in the UK, not just have residency. So yeah, I agree with that. Okay, now the key one, especially when you're looking to restructure and things. How does the law define redundancy? Because you hear so many people lay somebody off, re-employ somebody, etc. How does the law actually really define redundancy?
In essence, then, an employer ceases to carry on business or ceases to carry on business in that place, or essentially there's a diminution of the need for somebody in a particular role. And so the need for a role diminishes. So there's less work going round for the number of people that you've got, for example. Maybe, again, looking back at the COVID situation, I mean, I know from my own experience in the last year how many receptionists have found themselves redundant in the early stage. Roles where customer facing in that situation, there's going to be a significant less of a need for it, I would have thought. People have switched to switchboards. People are still working from home. There's hybrid working. I think the idea of somebody sitting on a desk at the reception area, especially in the sort of generally smaller company, where somebody can announce that they've arrived at the front door and they could be met by whoever it is they're meeting and taken to an interview room. These are things that employers will have been looking at. So a diminution in the need for somebody to carry out work of a particular kind would be the one most likely going forward.
Number 6. So we're halfway through, and I'm sure everybody in this is finding it fascinating. I certainly am. So what should an employer do if an employee refuses to wear a face covering when this is required?
Unless they've got some kind of medical exemption, for example. If it's a requirement of the job, then they've got to be removed from that workplace. If an employee doesn't have a legitimate reason for not wearing a face covering, then it's not unreasonable for an employer to treat it as the same as refusing to follow a reasonable and lawful request and failing to follow the strict instructions in terms of wearing of PPE. So I don't think it's any different to somebody going on the factory floor without their safety boots on for second or third time. I mean, essentially, if it's an absolute requirement of the role, I mean, care home maybe, any kind of environment where really the employer has a requirement to ensure that that is the case. Yeah, absolutely, Ben.
The one comparison I thought about was a welder. You wouldn't allow a welder to go on to his base.
Well, you wouldn't, Ben.
No, the contentious one. Can employers ask employees if they've had it says coronavirus vaccination on my question, but I suppose any vaccination these days now as it's back in the news, but particularly coronavirus because it's the one that's prevalent.
Well, you know what? I suppose it's a case of personal data, Ben. So like any other personal data these days with GDPR and, you're basically collating medical information. It has to fit in with a special category data. And I would have thought that you'd have to follow the usual kind of GDPR requirements. But again, if it's a requirement of the job, if an employer makes it as a matter of policy that an employee must have it, and let's face it, come November, we've got a legal requirement certainly in the medical social care sector for vaccinations. The answer is, again, if somebody says no, ultimately, if you've got a legitimate reason for asking and they say no, well, again, they're follow a reasonable and lawful instruction. If they're already an existing employee, using the scenario, for example, that you've told everybody that within 4 months everybody has to be jabbed or dismissed, in the context of a care setting, for example, then in the case of them, then you would commence disciplinary action. And in the case of somebody who's you're looking to recruit to a role and you've made it a condition of that employment that they are, if they don't produce it, then it's a condition you don't employ them.
It's all about reasonable, I think. That's the key word I've heard today is reasonable. I think it's reasonable.
Yes, I mean, if somebody produces their medical reason for not, then that's going to be reasonable. But I think just somebody saying dismissively, somebody down the street I knew was sick and bad after the vaccine, that's not going to cut it for most employers.
Okay, I like this question now, because obviously whistleblowers is always in the news. Can an employer anonymise witness statements obtained during a grievance or disciplinary procedure?
There are circumstances during an investigation where somebody may have given some evidence as part of a disciplinary investigation and they're worried about the source of it. I think if you're going to use that kind of evidence, then an employer should try and establish other evidence to help corroborate. If you see what I mean. Yeah, you can as an employer protect identity of an individual during that investigation. And sometimes, I've had situations where there's been serious allegations of bullying, which have stretched, and indeed corruption, and in some larger employers, which have stretched to outside of the workplace, including intimidation, especially where you've got workers that work closely together in teams, away from the protection of a supervisor. You have to respect people's fear. The problem is you won't get them coming forward in some extreme cases. So, yeah, I think you've got to be wary of the fact that in the context of a tribunal, an employer who has simply relied on one statement where somebody's name isn't up in lights and they're not available to give evidence, it's going to make the process a lot more unsafe in terms of being able to explain fairness if you haven't corroborated it elsewhere.
Yeah.
So I think the answer is there are circumstances, Ben, but like always with these things, you have to look at those circumstances, err on the side of caution, and just do a thorough job.
Yeah. Get your outs in order before you do that, I think. Is the key there.
Absolutely.
Yeah. Don't because you can be used as an excuse, can't it? Or they don't want to be known, whereas the evidence might be weak, shall we say?
Well, if somebody doesn't know where an allegation may come from, they're hampered arguably in actually defending themselves, because that allegation could be entirely spurious, or maybe there's 5% of it is true. If they knew that 5%, of course, they might know where it came from, where the source came from. I think you just have to take very cautious steps and make sure that you can corroborate as an employer. Yeah, very important.
Okay, home straight now, last two. First one, where a new employee is no longer able to start work on the agreed date, can the employer retract the offer of employment?
Typically, when I draft a job offer letter for clients, I typically ask the client, Is there a start date? And is it a condition of employment? And you'd make that clear. Sometimes you have situations that arise. I mean, last year, of course, we had employers making offers to employees pre-lockdown, and months down the line, they still hadn't started because even if they wanted them, they just couldn't bring them into work. There was no induction process, no way of getting them started and having them working from home. So if it's made clear it's a condition of it, yeah.
Final one. What is the companion's role at a disciplinary or grievance hearing?
Well, the role really is one where they can't answer. Obviously, they can't answer questions. That's the big one. A companion is not able to answer any questions on behalf of the worker who's in front of the disciplinary in the meeting. What they can do, though, is ask questions. Obviously, they're there as support. A proactive trained union rep is going to be a lot more beneficial to an employee than a friend who's worked in the same place and is a little bit nervous about speaking out against management, for example. The role really is to be able to confer with their colleague, with the worker, and chat, and that should really be very much in private, not in front of the disciplinary officer, but also they need to be able to ask questions on the employee's behalf.
That's been amazing. That has. I think that's answered a lot of questions for people. And I think the key for me is firstly communication. Wherever the situation is, communicate. And I think second thing, I figure out is flexibility where it's possible. Finally, and obviously prevalent point now, nothing to do with it with the quick fire question answer session. Furlough. We're at 60% now, aren't we, with regards contributions? Are we seeing a huge change period where people's jobs could really be threatened and etc.?
I'm personally not seeing it yet. I have to say that my own view is that is because, like me, some people are away. Holiday resourcing issues throughout the sort of school 6-8 week period. So I was just talking to somebody yesterday. They've still got a couple of people on furlough. They don't know. They know, obviously, that the government support is reducing, but they don't see themselves making a decision before the end of next month because they're seeing some of their larger accounts. There's a large manufacturer who's gone through a lot of change, but they're saying that they're picking up and expecting to get people back to work next month themselves. So I think a lot of employers, if the people who are at home are still valued, I think that's a big issue. But if they are still valued, and it's just the circumstances of the employer and the role, and if they're still on furlough, maybe not all lost, but statistically, I'm reading that at least 1 in 5 on furlough expected to be made redundant, and I'm surprised it's only 20% personally, but that's actually cautiously encouraging. What we don't want is a huge rapid increase in unemployment with little chance, with people applying for one role with 1,000 applicants. It gets very stressful.
We're only 2 months away from it being completely taken away.
We are, and I think this time round we have a vaccine, and there's some positivity from that. I think this time last year we were just expecting that second wave in the winter. No vaccine solution on the table, rolled out. So hopefully it won't be too bad, but yes, there will be casualties, Ben.
Yeah. I think like you, I think there will be casualties. I think the worrying thing is if you're not back within a company at the moment, how prevalent to that company are you? How important to that company are you? I think is the question, and that'd be the worrying thing. But God forbid, we want no redundancies because of COVID, but I think we have to accept it is going to happen, and companies are looking a lot slimmer, trimmer, and perhaps more profitable.
Some of them actually discovered that. Then no doubt that things are being done differently. Some companies have downsized their office space and are working hybrid systems, working on a rota. Getting people in. I mean, larger offices, I think that the Chancellor's comments earlier in the week about the importance of getting back into work from a networking perspective is a very good point, actually. I look back at my career in the law, and there's no real substitute for that initial forming of relationships and the picking of the brains of colleagues. It still goes on. We pick the brains of colleagues now, but I wouldn't like to come into an environment. I mean, something like the virtual law firm I work with, that's worked hard to create ways and means of bringing people together. But the one thing I've missed in the last 2 years is the actual physical get-togethers, where over a pint and a few hours, and sometimes a bit of fun and frivolity, you actually form friendships. Much harder to do that on purely online.
Yeah, on that, I went to Silverstone last Friday for a launch of Motul. Seeing whites of people's eyes, you get down to business straight away. You talk to people about it, and then you have a coffee and things. So it's almost the two. It's very difficult with the phone. But it's almost the two birds with one stone, isn't it?
Oh, absolutely. And as I say, that kind of networking, there's no real substitute for it. I think I'm finding that this kind of medium, earphones in and speaking to people 50, 100 miles away is great when you know people.
Yeah.
But, Ben, we've known each other for the best part of 20 years.
That's been a tremendous half an hour. Thank you much for your expertise, as always, Alasdair. It's put a lot of people at ease.
Thanks, Ben.
As always, if you do want any HR advice, get in touch with you in Results. There is no better company that can give you straight, practical advice, honest advice, and I would always give them a 5-star recommendation. Alasdair, as always, thank you very much, sir. You're an absolute gent.
Thanks, Ben.